Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Our first case this morning is number 19-1451, Hinkle versus Safeguard. Mr. Marshall? Good
Yes,
to have
sir.
you with us.
Thank you, sir. May I proceed?
You may proceed.
Thank you. May it please the court, Jonathan Marshall with the law firm of Bailey and Glasser, and I represent Robin Hinkle, the plaintiff appellant. This action arises from the sale of a debt cancellation insurance product that was made as part of the purchase of a car. The company that sold defendant's gap insurance product, Safeguard, was not licensed to sell insurance. None of the forms it used were approved by the insurance commissioner and therefore is forbidden from collecting a premium on the product. Plaintiff therefore brought claims under Article 2 and Article 6 of the West Virginia Consumer Credit and Protection Act related to the sale of the insurance and collection of the premium, because alternative forms of relief through the insurance code referenced by the district court do not provide any other direct mechanism to get a refund of the premium. She also brought insurance-based individual claims on the bad faith denial of her insurance claim. Your Honors, what happened to Ms. Hinkle is not an uncommon fact pattern. It has been the case where lenders, at the point in which a loan is made, insert improper fees. Indeed, it is nearly impossible to leave a dealership, it seems, without a dealer attempting to sell some additional product to you. When lenders, dealers, and other retailers cross the line and collect fees or other amounts of money that should not be collected, they should be held to an account. Now, I'm happy to tackle the issues in any order the court desires, but I'd like to try to get to the nub of the three issues as I see them quickly. So, with that in mind, Error 1, I'd like to address Article 2 first. The court dismissed Ms. Hinkle's Article 2 debt collection claims just because she paid the premium. Taking the court's logic further, according to the opinion, had Ms. Hinkle simply not paid or waited some unspecified period of time to pay after the transaction, she would have had a claim. This standard is unworkable and is not supported by the plain language of the statute, which defines a claim as being any obligation arising out of a transaction. Transaction being a critical term and connoting not only the discharge of a contract, but also, as set forth in the district court's opinion, the act or an instance of conducting business or other dealings, especially the formation, performance, or discharge.
Mr. Marshall, this is just Diaz, if I may. With respect to this particular claim, if I go to the supermarket and purchase a bag of groceries and pay at the point of sale and then leave the supermarket, under your theory, would I have a claim against the supermarket as a debt collector?
The answer to that question is I do not believe that you would, because here, in order to state a claim, this is only a threshold question, whether there is an actual debt collection in progress. Whether you have a claim or not, you have to actually refer to the substantive provisions of the actual code itself, i.e. there has to have been some sort of unfair, deceptive act or practice. Well,
but I don't know that you answered my question. So assume that I would later claim that there was an unfair or deceptive practice of some sort. Would I have a claim against the supermarket?
Yes.
So there's no limiting principle here. It doesn't matter the nature of the transaction. I mean, it seems counterintuitive that if you pay for something on the spot and the liability is extinguished at that point, that just doesn't sound to me consistent with the conventional view of what a debt collector is.
And that's an important point, or important clarifying point. So, this is, the definition of claim is very specific. And so in your fact pattern, yes, arguably there could be a claim if, again, that substantive conduct was met. But again, here, what we're addressing is really just a threshold question of what is a debt collector. Under your fact pattern, I couldn't imagine a situation in which a claim, ultimately a substantive claim, would exist. But here's the point. The point is, I can give you examples, and this is a prime example, where an illegal fee is inserted into the making of a transaction, a person pays for the fee, and they should have a claim under those circumstances in a typical type of credit transaction. This happens. And again, I understand the concern. I do understand the concern, but trying to impose some delay of payment requirement, whatever that might mean, is totally unworkable or very difficult to make work. And
Mr. Marshall, but the problem is that once you pay for the, whether it be a policy, a good, a service, whatever, in full at the point of sale, where's the obligation to pay money that results from that? There may be other obligations inherent in that contract that might result in a violation of some kind, but the whole gist of this statute is the obligation to pay money that results from the transaction. And in the scenario, in this scenario, your facts and my facts, there simply is no further obligation to pay money.
But I think the key here is the linchpin is the word transaction. And transaction means not only the discharge of a transaction or discharge of a contract, but it's its formation as well too. And so if that obligation arises out of that transaction, i.e. even the formation, then under the plain language of the statute, you have a claim. And again, I guess, and to the extent that there is ambiguity with respect to this statute, with respect to this application, the ambiguity should be decided in favor of the consumer. If the consumer is subject to an unfair or deceptive act or practice, they should have a claim. Whereas, under your situation, I mean, if the supermarket were to do something improper, the consumer should have a claim. The supermarket shouldn't be protected just because the transaction arose out of a point-of-sale type of situation. That's the way the Consumer Act works, and it's the way it's been construed, too. And again, it's not to say, under your circumstance, I couldn't imagine, and sometimes this is an example of, you can take things to their extreme, where a person would ultimately have a claim under those facts. But I can imagine a situation in which somebody goes to a dealership, they purchase a car. As part of the purchase, the transaction gets crammed with improper fees or some sort of improper product, and a person brings a case. And they should be able to bring a case under those circumstances, notwithstanding the fact that they paid for the product or service up front, or maybe even a little bit after the fact. And I think also, too, if one looks at what it means to have a deferral of payment, which the court held was not required, I believe the court held was not required, well, if it's not a deferral of payment, then what is it? And what it is a claim that rises out of a transaction. And a transaction...
This is Judge Wynn. I'm following up on Judge Diaz's question because I think that is the key to the case here in the interpretation of the statute. And we have here definitions for debt collector, debt collection, and claim. And it seems like it must have been, to be a debt collection, you must have been collecting on a claim at the time. And so we're constrained, notwithstanding, the arguments you're making, which may be a good policy argument, by what essentially the statute says, and to the extent that we can glean from West Virginia cases, how to interpret this. Now, what West Virginia cases do you say support this broader definition of claim that would expand what looks like the definition of debt collection to virtually any seller of a good or product, as Judge Diaz has alluded to? What cases are you relying on in West Virginia that gives us that direction on this broader definition?
And as the court knows, we cited a series of cases, the Saran decision, and to be perfectly blunt, Your Honor, we don't have a case that directly addresses this point. we have cases in which a transaction arose out of a point of sale.
Yeah, it's quite clear you don't have a case directly on point. If it was, we probably wouldn't be here. And I understand that, but the question really is, we've got to glean from the West Virginia cases at least what we would think that the Supreme Court of Appeals of West Virginia would do. So it's not explicitly addressed the question, but you do have some cases out there. You pointed to the Dunlap case and to the Caldwell case, for support on this. But how do we glean from that the West Virginia favors this broader definition that would expand it to virtually any seller of a good or product?
Yeah, I think the other case we cited was Fleet. And in each of those cases, particularly Fleet and Dan's Car World, where the court actually was addressing construing claim, the court held that the collection activity constituted or was subject to the act. This is not, but to answer your question, those are our authorities. And in each of those instances...
Well, if you take those authorities, you've got the two cases there, and they don't go to the question of the point of sale payments. What they seem to suggest is that a claim is a follow-on payment obligation for a prior transaction, which is not what you have here. And so I don't see the support that you can get from those cases for this broader proposition of the definition for claim.
And this is often the issue with this Consumer Act. We don't have a lot of authority. And the court, I guess the converse is true. There aren't any cases that say we can't do this. Obviously, we wouldn't be sitting here if we did.
Well, I just want to make it clear that the cases you cite are not really are not very helpful on that point, because they are not cases that those are cases that dealt with a follow-on payment obligation for a prior transaction. And it's not the case you have here. So that leaves us empty, as you say, without from your perspective, of any cases on it. So then we turn back to the statute and we seek to determine if there is a plain meaning here that we can glean from the statute.
I agree, Your Honor, and that's where I believe that the analysis lies.
Mr. Marshall, can I just follow up on that? So earlier, when you were responding to my questions, you said that the reason why we should allow for this expansive reading is because otherwise the consumer would be left without a remedy. But that's not quite correct, right? Because there are other provisions in the statute that provide potential remedies, including Article 6, which prohibits unfair methods of competition and unfair and deceptive trade practices, and you have an argument with respect to that. So the problem is, as Judge Wynn has pointed out, there's no case that supports, and you've conceded, that supports this really expansive reading of the statute. It is intended to be a remedial statute, but we can't, it also is not intended, I think, to remediate each and every potential problem that a consumer may face. There are other provisions of the statute, and perhaps you want to turn to that and tell us why you think the district court erred with respect to these other claims that you have.
I could. It appears I might be out of time, though. I haven't heard the chime.
You go ahead and answer the questions. I might have a couple questions myself as Judge King. You answered Diaz's question first.
Okay. So, as I looked at, I wasn't trying to make myself or make extra work by bringing this claim. The Consumer Act, the general provisions, this is Article 1 through Article 5, which includes Article 2, the debt collection provisions, is very concerned with overcharging. Admittedly, I brought an Article 6 claim also, too, because I felt that could be a potential avenue for relief. But in terms of bringing may I proceed? In terms of bringing the actual claim itself, Article 2, it made perfect sense because, again, the statute's concerned with overcharging. But with respect to the other two claims that are at issue here, particularly Article 6, this was an error that occurred. In terms of the plain language of the statute, the legislature had an intention when it prepared and it created this act. Now, some of the tension arises because it's a combination of two different acts. It's a combination of the UCCC and the National Consumer Act. And they had very somewhat differing or competing views on what should be regulated and what shouldn't be regulated. Now, with respect to Article 6, the legislature chose to define service to include insurance. That was an intentional decision. And it chose to define trade or commerce as including insurance, and it chose to prohibit unfair, deceptive acts or practices in trade or commerce, bringing insurance within the ambit of Article 6. Now, there is an exclusion for the sale of insurance, but that exclusion is tempered by except as otherwise provided in this chapter. Now, that's very important, and that intersection is very important, and that's where this tension between the UCCC and the National Consumer Act comes into play. The UDAP provisions and the Article 2 provisions we're talking about came from the National Consumer Act. And when commenting on the difference between those two acts, the National Consumer Act, and this is rare for West Virginia, we usually don't have legislative history or anything, but we actually have some here because we have the two model acts in their commentary. The National Consumer Act recognized that the Uniform Commercial Code did not include insurance and exempted it out. But there was an intention with the National Consumer Act to put it back in and to regulate it. And that's exactly what happened here. And again, our provisions come from the National Consumer Act. Now,
Mr. Marshall, Mr. Marshall, this is Judge King. When you were in the district court, you all sought to certify
yes.
a question to the Supreme Court of Appeals of West Virginia, correct?
Yes. Yes.
And that request for certification was denied?
Yes.
And was that issue the issue that you've been discussing here this morning?
Yes.
Okay. And what's your position on certification now? You haven't made such a motion on appeal.
I have not, Your Honor. I'm very concerned about these issues, particularly the Article 2 issue. I am very concerned about where the court might draw the line. I'm very concerned that if the court draws the line in a different place or a place that would be unworkable, that we may be exempting out certain transactions that are in desperate need of regulation.
Which court are you talking about? Are you talking about if the Supreme Court of West Virginia draws the line, or we draw the line?
All courts, any court, every court.
There's a big difference. There's a big difference. If we do it, we're just basically making a good estimation of belief as to what West Virginia is doing. If the Supreme Court of Appeals of West Virginia does it, that's just the way it is. So which one of those courts are you talking about drawing a line?
I'm concerned about both courts drawing a line, but I did make the request for the West Virginia Supreme Court to draw the line because
I'm just trying to understand your answer to Judge King's question. Are you asking for this to be certified? That we certify this to the West Virginia Court of Appeals, or have you just not abandoned that?
To be honest with Your Honor, I made
You've demanded it. Isn't that right?
I have demanded it. I asked for it in front of the district.
You have abandoned. You have abandoned
I'm sorry.
certification.
I did not.
You did
re-raise the issue.
You've abandoned certification. Now we could certify sua sponte, but you have abandoned that effort. Correct?
Correct. I did not renew it.
There you go. All right. You've saved some time. Let's see what Mr. Van Valkenburg has to say about this. Mr. Van Valkenburg, you there?
Yes. Judge King, Judge Wynn. Thank you, Your Honor.
Good to have you with us.
Judge King, Judge Wynn, Judge Diaz, may it please the court. This is Jeff Van Valkenburg. I'm here with my co-counsel, Deb Varner. from the law firm of Varner and Van Valkenburg in Clarksburg, West Virginia. We're here on behalf of the appellee, Safeguard Products International, LLC. The court has honed in directly on the issue that the parties have spent an extensive amount of time briefing, which is whether Safeguard is a debt collector engaged in debt collection. The court's analysis and questioning obviously is honed in on the specific issue, and initially, to circle back to the example that was discussed concerning the purchase of groceries that Judge Diaz had questioned counsel about, in that particular instance, there was no action by the grocery store that would bring this type of transaction into what would commonly be referred to, and pursuant to the express language of the statute, into what we would call debt collection. Appellant is cited to multiple cases discussing the West Virginia Consumer Credit Protection Act as well as the FDCPA. None of those cases in any way, shape, or form support the position that appellant has taken concerning the Article 2 claims that are before the court. Now, in light of the district court's reconsideration of its initial ruling on the motion to dismiss that was filed, I think all parties can agree that the requirement of some deferred payment is not a necessity for purposes of the Article 2 claims. However, every single case cited under the West Virginia Consumer Credit Protection Act, as well as the FDCPA, requires something more than a simple point-of-sale transaction. Each case, whether discussing a dishonored check, a failure to pay homeowners association dues, or utility payments, required some additional conduct. And that's what brought it into the gambit of these respective statutes. That simply is not present here. What happened here was a simple one-time payment that was made for purchase of the Safeguard Gap Addendum. There was no additional conduct by Safeguard to try to collect any sum from Ms. Hinkle, the appellant herein. There was no additional contact from Safeguard until such time as the claim was made approximately 5 years after this transaction took place. Discussing some of the cases briefly, the Bass decision that's been heavily discussed within the briefing of the parties involved a dishonored check. This was an FDCPA claim. And so that check being dishonored triggered the collection efforts, and that then triggered the potential FDCPA claim. So without that particular conduct, had the check been honored, there would have been no claim under the FDCPA. Fleet versus Weber Springs, which is a decision discussing the West Virginia Consumer Credit Protection Act, was an action against homeowners to enforce liens for HOA assessments. Again, if the parties had undertaken the original agreement, there would have been no action under the West Virginia Consumer Credit Protection Act. And
this is Judge Wynn. The statute defines a claim as any obligation to pay money arising out of a transaction. Why wouldn't a typical customer transaction like this one here, which is the exchange of money for a service, result in an obligation to pay money that, quote, arises out of, end quote, the transaction?
Your Honor, the district court undertook a detailed assessment, understanding that there were several terms that were undefined within the definitions under 46A to 122, including debt collector, debt collection, and claim. And under that particular circumstance, we have to focus in not only on the term claim, but also the inclusion of the term consumer, which is included within that definition of claim under 46A2, 122B. And under the definition of consumer, what is required under these circumstances, a consumer is defined as any natural person obligated or allegedly obligated to pay any debt. And that is the critical consideration here for this particular analysis. Because when we include the term debt within that particular analysis of what is a claim, we get back to an undefined term within the statute. And so Judge Copenhaver did a very good job of walking through the various terms that were undefined, including the term debt, which he defined as having a liability on a claim, a specific sum of money due by agreement or otherwise. And that's from Black's Law Dictionary, 10th edition. and that's in page 17 of his order. And he also cited to Osborne versus United States, which found that West Virginia has been consistent that undefined words and terms used in a legislative enactment will be given their common, ordinary, and accepted meaning. So, taking that undefined term of debt, utilizing the common definition in Black's dictionary or under Merriam-Webster, which means something owed, an obligation, or a state of being under an obligation to pay or repay someone or something in return for something received, a state of owing. Taking that analysis, there has to be some further obligation after that initial point of sale transaction, and that simply was not present here under the analysis.
Mr. Van Valkenburg, can I ask you to turn your attention to the other issues on appeal here, and just put aside for the moment the question of whether or not insurance is defined or excluded under the relevant statute. But I wanted to talk about the claim that the plaintiffs had with respect to bad faith and breach of contract and unfair trade practices regarding the gap insurance coverage. And so the district court in this case found that no reasonable person would credit or expect credit for one's own delinquency to be part of that coverage. And intuitively, that sounds correct to me, but I wonder whether it was proper for the district court to find as a matter of law that no reasonable jury could conclude otherwise under this West Virginia doctrine of reasonable expectations. As I understand, that requires a showing of two things. First, that there be reliable and relevant evidence, in this case, extrinsic to the gap addendum, that would cast doubt on whether or not the plaintiff's claim was covered. And then second, that their expectations regarding the addendum's coverage were objectively reasonable. Now, on that first point, but this universal underwriters case essentially says that even assuming that the contract is unambiguous, the question is whether or not there's any extrinsic evidence that casts doubt on the otherwise expressed terms of the agreement. So why wouldn't the salesperson's pitch to her that no matter the circumstances she would be covered cast that kind of a doubt?
Your Honor, thank you for raising that issue, and it is an important one. Now, it's important in this particular instance to drill down, I think, on the specific facts involved in this particular case. The gap addendum involved a $495 purchase price, and it's a two-page document. Universal Underwriters dealt with a 200-page insurance policy. In this particular instance, the appellant, Ms. Hinkle, confirmed while being deposed under oath that she had read the agreement, that she had signed, or her husband had signed the agreement when they were there, when they were there purchasing this automobile. The key terms were the actual cash value and unpaid net balance. In this particular instance, it is undisputed that following almost immediately the purchase of this automobile, Ms. Hinkle and her husband began to miss payments, request deferred payments, incurred late fees. In appellant's position, and it has been since the initiation of this matter in 2012, was that despite these facts and despite the definition of unpaid net balance specifically excluding any late payments, deferred payments, or missed payments, that they were entitled to the recovery of the entirety of the amount owed at the time of the automobile accident in excess of the fair market value of the automobile. Had appellant made all payments under her retail sales agreement for the purchase of this automobile, appellant would have actually received approximately $2,000 from her liability insurance carrier. Now, undertaking this analysis, utilizing what is reasonable under the circumstances, the purchase of a $495 gap addendum, which was designed to cover any overage over top of the payment that her liability carrier would have provided, undertaking that reasonable assessment, I believe the district court correctly decided that under the circumstances it was unreasonable for someone to demand that. Not to go through the parade of horribles, but under appellant's assessment of this analysis, she could have just not made a single payment under her automobile retail sales installment contract, and then gotten an accident and expected safeguard for the $495 to cover the entirety her automobile overage at that time, which would have been the entirety of the actual purchase price. So when we're talking about this assessment of reasonable expectations, and a dealer says, well, yeah, it'll cover, any damage to your car, understanding that there are specific terms in the 2-page document that Ms. Hinkle read, the district court correctly decided that this simply was just not a reasonable expectation under the circumstances, and even a trier of fact would have decided the same thing, and there was no need to get to the trier of fact based on the explicit terms of the agreement, as well as the analysis of the specific facts of this particular matter.
So the particular statement that the salesman made, as I recall, was that the gap insurance would cover whatever the insurance didn't pay. And understanding what you just said about we're not dealing with a complicated contract, there's some evidence in the record that she may have skimmed, if not read the addendum's terms. But doesn't that statement suggest perhaps that a reasonable juror could find in her favor based on that sort of blanket the insurance would cover whatever the insurance didn't pay?
Your Honor, to your question.
And to be plain, I mean, I'm not suggesting that she's entitled to judgment as a matter of law, because intuitively, as you point out, it just doesn't seem to make sense. But that doesn't mean, the question is whether or not she's entitled to get in front of a jury.
Right, Your Honor. I don't believe that's the case in this particular instance. The West Virginia Supreme Court of Appeals has been very clear that it is not incumbent upon someone who sells an insurance policy to sit there and walk a potential purchaser of a policy through every single provision of an insurance policy. And frankly, from a public policy perspective,
but that's different than representing an insurance policy to be something different than what it actually is, which is what is contended here.
Well, yes, Your Honor, but under normal circumstances, you wouldn't expect a person to miss payments, incur late fees, and then expect the purchaser, or expect the insurance policy in this particular instance to just cover that amount. Under a normal circumstance, assuming a
Well, in southern West Virginia, a lot of people miss their car payments. These coal miners go in and out of work all the time, and that kind of thing. Actually, they're charging them like on this loan 14% on a car loan, it's because they don't make their payments.
And that's
the expectation would be they will miss payments.
Well, the reasonable expectation may be that they will miss payments, but the reasonable expectation also is that for the purchase of a $495 gap addendum, that you can't expect someone in that or a company in that particular industry to cover the entirety of that debt. As a business model, that would be completely and entirely untenable, and that's why they specifically include the exclusion. That's why they include the language on the first page near the signature that says that I have read the entirety of this gap addendum. And
well, any ambiguity is construed against the insurance company, isn't it?
But Your Honor, respectfully, I don't believe.
Isn't that right?
That is correct. But in this particular,
did the Bingo County Circuit Court rule that it was ambiguous?
Your Honor, the Santander had filed a motion.
Did the Bingo County Circuit Court rule that was ambiguous?
I believe so, Your Honor, in relation to Santander's.
And it made some rulings that then they took it to the Supreme Court of West Virginia trying to get it turned around. You all did, and you lost. And so the Bingo County rulings would be the law of the case here. When it came into the federal court and was removed after those rulings, that was the law of the case. And not only that, it's the law of West Virginia. That's why I guess that's why the Bingo Circuit Court ruled that way.
Your Honor, the issue in front of the West Virginia Supreme Court of Appeals was whether this product was insurance or not, which was a novel issue and had not been addressed by the Supreme Court at that time.
That was what you tried to get prohibition, and it was denied.
That is correct, Your Honor. subsequent to which the legislature.
So when it came over to the federal system, that was the law of the case. It's the same case, right?
Yes, Your Honor.
Mm-hmm. And did you resist the effort to certify, or was that you take a position on that?
We did resist the effort to certify. We had, in conjunction with that, filed the motion to dismiss the claims themselves under the Consumer Credit Protection Act, and the court, before we got to the decision on the certification, issued the motion, ruled on the motion to dismiss, which rendered the certification issue moot at that point.
Well, the certification issue was denied. The certification request was denied, but it was denied at the same time the judge ruled in your favor.
Correct, Your Honor.
Okay.
Your Honors, I believe my time is about up. Unless the court has any additional questions, I believe I'm concluded with my argument at this point.
Well, Judge Wynn, you got anything else?
I do not.
Judge Diaz?
I don't. Thank you very much.
Thank you, Mr. Van Valkenburg, very much. We appreciate it.
I appreciate the opportunity to appear before you today. Thank you so much.
Good to have you here, and sorry that it has to be on a telephone setting. Well, maybe next time we'll have you in Richmond.
I will look forward to that, sir. Thank you.
Yes, sir. Mr. Marshall?
Yes, sir.
You saved a few minutes. Go ahead.
Thank you. So I want to first address the Article 2 claim again, and particularly I want to take issue with one thing that Mr. Van Valkenburg mentioned, and that was conflating the definition of consumer with claim. The issue in this particular instance is not the definition of consumer. The issue that has been raised is the definition of claim. And claim, which is in subsection B, debt collection, which is in subsection C, and debt collector in subsection D, of course, all refer to one another. The definition of consumer was added later. And so when the court is construing the word claim, the relevant subsections really are B, C, and D. And that was one of the issues, I believe, that came about as a result of the court's formulation. The court inserted the word debt into claim. And the word debt is not in the definition of claim. It is simply a transaction. And the use, again, of that word transaction was intentional, as provided for in the National Consumer Act. And this is commentary, this is in the Joint Appendix. Transaction is a vital term throughout the Uniform Commercial Code and this Act. It is nowhere defined in the code. This definition ties it to the emphasis that this Act places upon a true agreement by the consumer to avoid allowing a merchant to use technicalities of contract law as a means of avoiding his obligations and responsibilities. This definition makes it clear that there need not be an enforceable contract, so as long as there is an agreement, which is a bargain of the parties, in fact. And so the definition of transaction, again, is very important. And as to the issues as to authority, again, there are no cases that say that this is not a proper construction. The court does have to construe the statute, but in construing the statute, the purpose here is to construe it in such a way as to protect consumers. And so in the example of a retailer engaging in an unfair or deceptive or bad practice in violation of Article 2, they should be held to account under the Act, regardless of whether the consumer paid during the course of the transaction or at some point later. With respect to Article 6, which is the unfair, deceptive acts or practices claims. Again, that same framework should be applied with that particular claim as well, too. You have a situation in which the legislature intentionally used the word insurance to define terms. you have an exemption, but then you have a exception to the exemption, which applies. And again, looking at the history explains why that exemption exists as well as why the exception exists. These are intentional words. But to the extent that the court does find ambiguity, it has to be drawn in favor of the consumer. And a very good example of that line drawing process is the Barr decision, which the defendant cited, Safeguard cited here. And in that particular case, the court was asked to construe the word creditor as used in one of the remedy sections. This is 46A-5-101. And
Mr. Marshall, Judge Wynn, before you conclude, there's something that's overarching about this case that I would like for you to address, and that goes to the reasonable expectation part of this case that Judge Diaz got into in the colloquy somewhat. What reasonable person would believe that an insurance policy will take care of your late fees and delinquent payments? And address it from the perspective that your opposing counsel gave it, that is, if that is the case, then why would you make any payment? And because if you didn't make any payment, then the policy would cover everything in the event you had an accident or something.
That's a fair question. I'll address it this way. There has been a bit of an undercurrent here, not explicit, that perhaps somebody might take advantage of this doctrine in such a way as to essentially game the system.
Let me be clear, at least in terms of what we're talking about here. These are late fees and delinquent payments we're talking about, right?
So what happened was...
But I'm just trying to get a clarification on that. You're not really talking about the value of the policy that of the property that wasn't paid by the insurance company just by itself. What you were talking about is essentially additional obligations that came about because of the failure to pay in a timely manner and delinquent payments here, the fees and things that added up.
Yeah,
which would arise if you didn't pay anything. Is that what we're talking about? Is what I'm asking.
So what happened? Yes, Your Honor. What happened was clients, just like Judge King mentioned, fell behind.
I got that part. I'm just trying to understand. Even if you do, how do you buy an insurance policy to say if I don't pay, you'll pay for me if the car is in an accident?
So let me just go one step further and say, client worked with the lender to try to resolve the delinquencies and worked. The car was never repossessed. She fought to catch up, and we're able to work out an arrangement where there were some payments placed at the back end of the loan. So from her perspective, she is taking care of her obligations, albeit there are financial difficulties here. And really what makes this different is that, and this doesn't happen in the normal course of when you buy an insurance policy. You actually have a salesperson there. That's common. But you have a salesperson who is selling an unlicensed product and making representations. And what's very unique here is that you do not have the salesperson testifying, I didn't say any of those things.
Didn't say what? So, didn't say I'm going to pay if you don't make your payments and you get late fees and delinquent payments?
Oh, did not contradict this notion of, well, look, there are certain. May I continue?
Finish that answer. Go ahead.
Okay. Did not contradict the notion of, look, if you're in an accident, if there's amounts left over, we're going to step in and pay that. And again, and from her perspective, this is not a situation where these are just late fees or this is just a complete failure to pay. She fought with the lender to try to catch up. And so under those circumstances, I think it was reasonable for her to say, this is going to cover me, whatever the circumstances. And again, this particular analysis is very fact-specific, right? I mean, it's hard to draw generalized rules across the board. But with respect to this particular set of facts, where you have an uncontradicted testimony, why wouldn't she rely on the lender to try to catch up? And so under those circumstances, I think it was reasonable for her to say, this is going to cover me, whatever the circumstances. And again, this particular analysis is very fact-specific, right? I mean, it's hard to draw generalized rules across the board. But with respect to this particular set of facts, where you have an uncontradicted testimony, why wouldn't she rely on the person who's selling it to her. And very much likely, it's extremely possible this person had no idea what he was selling. There's no evidence in the record that he was trained. And I would also point out that this was a car purchase. Obviously, Ms. Hinkle was sitting there signing a bunch of documents. And if you look at this thing, I've looked at it many times, and this is all I do is practice consumer law, and I find it hard to understand. And it's small, very small, tight print. I mean, again, why wouldn't she rely on the statements made by the sales representative?
Mr. Marshall?
Yes.
We appreciate it.
Thank you.
Thank you very much. Your case will be submitted, and the court will take a break. And that's what we have, Madam Clerk.
Yes, sir.
All right, that concludes the case. We'll take a break.
This court will take a brief break before hearing. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Our next case is number 19-4307, the United States versus Hogue, if I pronounced that correctly. The appellant is represented by Ms. Tarleton.
Yes, Your Honor. I am, Your Honor. Thank you. Good morning.
Good to have you here.
Thank you. May it please the court. Jackie Tarleton for Jeremy Huff. Jeremy Huff was sentenced to 78 months in prison for possessing a firearm without using it, brandishing it, or discharging it. That sentence resulted in large part from a sentencing enhancement for using a firearm in connection with another felony. But Mr. Huff denies committing that other felony, which was weeks prior, involved a completely different firearm, and was a completely different kind of offense. And the district court clearly erred in finding, without any evidentiary support, that Mr. Huff disposed of the firearm from the shooting and got the firearm he was arrested for possessing, quote, because he was aware of what he had done on the day of the shooting. The Sentencing Commission instructs that two offenses are in connection with one another when they are part of a single episode, spree, or ongoing series of offenses. And the Commission instructs courts to consider three things before applying that in connection with enhancement. They are similarity, regularity, and temporal proximity or time interval. With regard to similarity, the offenses in this case are completely dissimilar. They involve, in one case, a shooting, and another case, a simple possession offense. They occurred in different locations with different guns. There were no other common facts. With regard to regularity, as the Sixth Circuit explained in Amerson, the government presented only two incidents, the shooting and the felon in possession offense, and that is the bare minimum for purposes of regularity. With respect to time...
This is Judge Wynn. Let me go to what I think is the heart of this question, which I think is a hurdle you may need to cross first, and that is the harmlessness inquiry. Because even if we do find procedural error was harmless, we don't need to address the other issues. And in this instance, the district court went on to say it would impose the same sentence as an alternative variant sentence here. And that's language that we and others have looked at and said, well, you know, if you're going to do the same thing, even if it was error, even if the upward departure was error and the guideline enhancement was error, then, you know, there's no need to go there because we've essentially, the judge has given this alternative variant. So why does that not make it harmless in a matter that moves it beyond the inquiry on the enhancement and the upward departure?
Because, Your Honor, the government has the burden to show that any error is harmless beyond a reasonable doubt. And here, I don't think that it can properly be said that if the district court had not believed that Mr. Huff had participated in the shooting, that it would have imposed the same sentence. So I think that...
Now, let me make sure what you're saying. Isn't that what the district court said it did? He said,
well,
you know, even if I didn't consider this, I'd give him the same sentence. I mean, so you're saying essentially this court didn't mean what it says?
I don't think that this court can credit an articulation by the district court that it would have sentenced someone for possessing a firearm the same way, but with the same sentence, if it believed that someone had committed murder or not. I don't think that's consistent with this court's 3553A cases. And I don't think it's consistent with a consideration for the history and characteristics of the offender or the circumstances of the offense. So no, I don't believe that that can be credited beyond a reasonable doubt. Of course, if the district court does want to reach the same conclusion, it can make an attempt to justify the extent of that variance on remand. But I don't believe that in a situation where you have a defendant who are otherwise similarly situated, one is found to have committed a murder and the other is not, but simply threw a firearm into the bushes. I don't think that those two defendants would be sentenced similarly under this court.
Carlson, this is Judge Diaz. So following up on Judge Wynn's question, so under the 3553A factors that the court would consider in fashioning an alternative variant sentence, I don't think it's correct to say that the court couldn't consider your client's alleged involvement in that prior murder, even if it erred in finding it to be related conduct. I suppose the court could consider that for what it was worth, but there was more here than that. I mean, it was the defendant's deplorable prior record history, some of which was not properly scored. The district court also referenced the defendant's less than, as he put it, contumacious behavior in court as apparent disrespect for the proceedings, which of course we can't see because ours is a cold record. So it wasn't like he just said, if I've made a mistake, I would have imposed the same sentence anyway. He actually went through the factors and explained why, in his judgment, given all the other relevant considerations that a district court is entitled to weigh in deciding an appropriate sentence and assessing your client's arguments for why a guideline sentence was more appropriate, he came to the same judgment under that alternative view. And it just seems hard to me to see how we can upset that balance, which is almost always left at the discretion of the district court.
I think, Your Honor, that respectfully, the shooting offense is the elephant in the room, whether or not the district court purported to rely on it in significant respect under the 3553A factors. I would note that the other factors that the court cited, including the unscored offenses he's referring to were more than 13 years prior to sentencing in this case, and they resulted, 3 of those cases were misdemeanors, and they occurred when Mr. Huff was 22 years old or younger. So I don't think that is sufficient to justify what would have represented a tripling of the advisory guideline range if the district court had erred in applying the in connection with enhancement. So I don't think that under this court's cases that require the district court to justify both the fact of the variance and the extent of the variance, that the district court's reasoning is sufficient in this case. I think that's especially borne out when you look at the way that the evidence was presented in this case. The government had every opportunity to bring any witnesses it would like, introduce any evidence from what it believed to be the murder in state court, but it didn't do so. Instead, it brought in an agent who had only begun to review these records the day before. This is not someone who had interviewed Mr. Huff or Mr. Boyd, wasn't someone who had interviewed any of the witnesses in this case. At JA 70, he said that he started going over reports the day before the hearing. At JA 74, he explained that he wasn't there at the date of the photo lineup at which Mr. Boyd allegedly identified Mr. Huff. He explained that he hadn't seen the lineup, even. He didn't see the photographs. He did not see the cell phone records that the government believed demonstrated that Mr. Huff had been at the scene of the shooting, and that's at Joint Appendix 80. He also saw none of the first-hand statements that were made. That's at JA 81. So I don't think this is a situation where this court is meaningfully deferring to the district court's credibility determinations, where the credibility...
I'm sorry to interrupt, but you're making a very passionate and eloquent argument that might win the day in a criminal trial if there was a requirement to find proof beyond a reasonable doubt. But of course, that's not the requirement in a sentencing proceeding. The district court simply needed to be satisfied by a preponderance of the evidence that Mr. Huff committed the murder. And you highlighted a number of issues that perhaps lead to some inconsistencies in the evidence, but there was also, as I understand it, evidence that the victim identified Mr. Huff in a photo lineup before he died, that he had admittedly some, not all, of the characteristics that the victim described, and that your client's cell phone was present at the place and time of the murder. It seems to me that a district court could reasonably conclude, based on that and other evidence in the record, by a preponderance of the evidence, that in fact your client committed the murder. And on appeal, we have to find that and make a finding that that is clearly erroneous. And I have to say that I think it's difficult for me anyway to come to that conclusion.
The standard, Your Honor, is certainly by a preponderance. However, there's also a requirement that any evidence relied upon at sentencing bear sufficient indicia of reliability. And here you're correct that Mr. Boyd was allegedly identified Mr. Huff in a photographic lineup, but that was on the third interview. During the first two interviews, he gave no information. That's at Joint Appendix 75. And at that third interview, his description of the shooter included a lot of facts that don't apply to Mr. Huff. For example, that he was a male known as Hood, that he was 5'10 or 5'11, and that he had tattoos. Mr. Huff does not have an alias of Hood. He's 5'6" tall. He has no tattoos. And again, we had no evidence presented at the sentencing hearing as to what kind of photographs were presented or whether there was any concern that the photographic lineup was unduly suggestive. There was also significant evidence by other witnesses. There were approximately 15 people at the scene of the shooting. None of them, with the exception of Mr. Boyd on that third interview, identified Mr. Huff, including the mailman who said that it was someone wearing a do-rag, Pickapoo, who said that it was two people who were both black, both wearing do-rags, Jose Lopez, who said it was a, quote, a black guy with shoulder-length curly black hair with blondish tips. That's at JA 78 and 79. And with more than 15 people there, nobody other than Mr. Boyd identified Mr. Huff. And with respect to Mr. Boyd's alleged statements, all the district court had to rely on was the third-hand hearsay of Agent Baer, who had simply reviewed the reports of another officer. So this is not a situation where I believe that the district court had sufficient indicia of reliability to come to the conclusion that by a preponderance of the evidence, Mr. Huff had participated in the shooting. I also
these types of proceedings always include hearsay, don't they?
They can include hearsay, Your Honor, but I think hearsay would be a generous interpretation of what happened in this case. This is not a situation where you have the case agent describing the demeanor and statements of direct witnesses. This is a situation where you have an agent who has no familiarity with this case other than a cold record review, testifying about facts he has no personal knowledge of and not even any sort of case-specific knowledge of prior to his review of those reports. I also think it's very significant that the district court purported to find as a fact, and I believe there's no question that this is clearly erroneous. This is at JA 99. He found that Mr. Huff disposed of the firearm from the shooting and got the firearm he was arrested for possessing, quote, because he was aware of what he had done on the day of the shooting. That is supported by no evidence. The government never presented any indication that Mr. Huff had disposed of the firearm, the .380 from the shooting, gave no evidence on that point, nor did it provide any evidence on how Mr. Huff or when Mr. Huff acquired the firearm that was possessed in the felon in possession case at issue here. As we noted in our briefing, these were different guns. The gun that was involved in the shooting was a .380. The gun that was found at the felon in possession offense was a 9mm. The second gun had pink markings. There was no evidence of pink markings on the first gun. And the circumstances of the offenses were completely distinguishable. In the first offense, obviously, we're talking about a shooting that resulted in a murder. In the second offense, it was a gun that was simply thrown into the bushes. So those are two very different types of offenses. And even though these were 2 weeks apart, that is not sufficient evidence of contemporaneousness under Amerson, which finds that when the court is going to overcome a total lack of regularity or a total lack of similarity, it's going to have very significant evidence of temporal proximity, and that's usually a contemporaneous event. It cites the cases of Powell and Conway, where firearms were possessed the same day of the offense that was deemed to be in connection with that felon in possession. Your Honors, in this case, the guideline range for Mr. Huff should have been 21 to 27 months. And after the district court heard only the statements of an agent who began to review the records the day before, he found by a preponderance of the evidence that Mr. Huff had committed that shooting, and in fact that, which would be evidence of a consciousness of guilt, had disposed of the weapon to acquire the weapon in this case. That was completely unsupported in the record. Again, that's at JA 99. I don't believe that the district court can simply say whether or not this shooting was committed by Mr. Huff, I would impose the same sentence, because I don't think that that properly accounts for this court's requirement that the district court justify the extent of any variance, which here, again, is triple.
Can I be clear about that? The question is not whether or not, I don't think, whether or not, as I understand the district court judge's findings on the alternate variance sentence, his finding was if I made a mistake in the findings with respect to the enhancement, that is, whether or not this was related conduct. But there's the separate issue of whether or not the government actually proved that your client was involved in the murder. And certainly if he found that, the district court found that, independent of whether or not it was related conduct, the district court could consider that, right?
The district court could consider that, but that's again where I think this finding, this clearly erroneous factual finding of JA 99 is so important. Because if it were in fact proven by the government that Mr. Huff had disposed of the firearm used in the shooting, I think that would be evidence of consciousness of guilt, which would be additional evidence that Mr. Huff in fact committed the shooting that occurred in April. And I think that that would have provided additional evidence that Mr. Huff was involved, supporting the district court's ultimate factual finding on that issue. Because that central issue was based on a clearly erroneous factual finding, that's why I think vacature and remand is appropriate in this case, so that the district court can appropriately evaluate the evidence that was actually presented by the government, considering the fact that there's no evidence to support that at all. And we don't know from the district court's statements at the sentencing hearing how significant a factor that consciousness of guilt may have been. The district court did say that it found by a preponderance of the evidence that Mr. Huff was involved in the shooting, but it didn't explain exactly which evidence it found persuasive and how it reached that conclusion. So I think that vacature and remand is the appropriate course. Again, if the district court believes that it can get there without that evidence, it can say so on the record, and this court can evaluate that determination if it's appropriate at a later date. But I don't think that on this record, with such a significant, clearly erroneous factual finding, that this court can affirm what the district court did in this case. I also wanted to emphasize the Seventh Circuit's language in Ritsema, which I think is very helpful. It talks about the purpose of relevant conduct, and it states that the relevant conduct is allowed to be considered at sentencing so that the sentence can reflect the actual seriousness of an offense. Obviously, in the ordinary course, if the government wishes to prove that someone committed a crime, they need to charge it based on probable cause, prove it to a jury beyond a reasonable doubt, and ultimately a sentence can be imposed. Relevant conduct is certainly a significant exception to that ordinary requirement, but I don't think that under the criteria given by the Commission, that an unrelated shooting with a different gun, with vigorously contested evidence that will in fact be tried in state court and sentenced if appropriate, should be swept in under a preponderance of the evidence standard by testimony given by an agent who has no independent personal knowledge of this case. I don't think that the Commission intended for this to be how relevant conduct would be used, to sweep in this significant of an offense at such a low bar by evidentiary standards to enhance a sentence by triple. So I would ask this court to vacate and remand the district court sentence and remand for resentencing without application of the enhancement.
Thank you very much, Ms. Tarleton. Your client certainly seems to me to be well represented.
Thank you, Your Honor.
Mr. Rickey?
Yes, good morning, Your Honor. May it please the court, Evan Rickey on behalf of the United States. The government, Your Honors, this morning is going to ask you to affirm the judgment of the district court. And I want to begin by just going over some of the pieces of evidence that the district court relied on in terms of a finding that Mr. Huff, by preponderance of the evidence, was responsible for that shooting of Mr. Boyd.
Let me ask you this. I want to focus on this one particular part of that. How can he find that he threw the weapon away?
Your Honor, yes, Your Honor. I believe that what the district judge was...
However he called it. Yeah, go ahead.
Right. Your Honor, I believe that the district judge was making an inference based upon the fact that that weapon was not subsequently found. And so that's how I view that, as him drawing a reasonable inference.
But an inference, a permissible inference, has to be based on some facts, does it not?
It does, Your Honor, and I do think the fact that the evidence showed that Mr. Huff, fled the scene of the shooting, that when he was encountered a mere 2 weeks later, driving the same kind of car that the witnesses said that he was driving on the day of the shooting, and that he's found in possession of a different weapon, I think it's a reasonable inference based upon those pieces of evidence. And Your Honor, so
it's almost like though, since he didn't have the weapon, that he disposed of it. So
yes, Your Honor. It is an inference.
It's based on the fact that he's guilty, and he didn't have the weapon. So the court finds that he threw it away.
That's right, Your Honor. That's how I read the record. That's how I understand that statement that was made by the district judge. But I do think it's important to emphasize some of the evidence that was before the district judge. I mentioned the dark-colored Lexus. Both Mr. Boyd and the other witnesses, including the mailman, talked about the suspect driving away in a dark-colored Lexus. That is, in fact, the car that he was driving on the day that he was arrested, on the day of the second incident. He was described as a light-complexioned black or Hispanic male with a braided hairstyle. Very significantly, Mr. Boyd, the shooting victim, initially told the Raleigh Police Department that the shooter was from New York, and as we know, that identifying bit of information is corroborated from the defendant's criminal history, that he was a resident of New York. He was from Queens. Talked again about the shoulder-length braided hair, and he gave enough information. Mr. Boyd did, the shooting victim, gave enough information for the Raleigh Police Department to be able to put up a photo array, to show him a photo array. And he, Mr. Boyd, identified Mr. Huff with a 100% certainty. Now, as members of this panel have observed...
Your adversary there says that it was the third time that he looked at it.
Yes, Your Honor, that is correct, but nevertheless, he made the identification. And one point that I think is important, much has been made about the fact that the sole witness at the sentencing hearing was not the case agent involved in the investigation of that shooting. But there's nothing improper about that. Hearsay is allowed. Quite often we can, the government actually invariably in sentencings will provide information on a hearsay basis through a summary witness. And so there's nothing at all improper about that. I would also say that since this was not a criminal trial, there was nothing preventing the defense from calling the law enforcement officers who put together the photo array, who questioned Mr. Boyd before he died. Now, they made a strategic choice not to do that because of the pending charges in state court, but I don't think that this forum ought to be used in order to relitigate a lot of the issues that were litigated before the district court on a preponderance of the evidence standard. And Your Honor, the other significant piece of evidence tying Mr. Huff to the shooting was the cell phone location data. And I want to emphasize here that the record shows that this was not cell tower location data showing that maybe he was in the vicinity. This was actual GPS coordinates showing him at the scene of the shooting on the 4,000 block of Green Road in Raleigh. And so that was sort of like the series of facts that the district court was looking at in assessing.
So what the data would show is that his cell phone was at the location, not necessarily that he was there, right?
Correct. And again, it's an inference, in this day and age that we carry our cell phones with us, hold them tightly. You don't leave your house. Maybe you have your keys, your wallet, and your cell phone. So again, it is an inference that his cell phone was there. His car was there. Again, the same car that he was driving the day that he was arrested. But Your Honor is correct. It is that his cell phone was there, not that he personally was there. For that, we have the identification of Mr. Boyd. And the other point I'd like to make, and I think this is an important one, what we see in the record, it's a very unclear picture of Mr. Boyd because it's been photocopied and scanned numerous times. Keep in mind, the district court was looking straight at Mr. Boyd. This sentencing occurred over 2 separate days. The district judge was looking directly at Mr. Huff, and he could see, to what extent does this man standing in front of me, does he match up with these descriptions that I'm hearing in testimony from the law enforcement officers. So in view of those bits of evidence, I don't think it can be said that it is clearly erroneous for the district judge to have relied upon that evidence. Certainly, in a trial setting, there are plenty of arguments to be made, holes in the evidence, perhaps different inferences that can be drawn, all of those things that would happen in a trial setting. But that's not kind of the posture that we're in now. We're now looking back at what the district court did and asking, was it clearly erroneous for the district court to find, based upon these pieces of evidence, that shooting was connected to the possession of the firearm for which Mr. Huff was charged. And I'd keep in mind, with the Amerson case that has been cited to by the defense, in that instance, you had a 3.5-month gap. You also had a shotgun in one case, you had a pistol in the other. In one instance, you had Mr. Amerson being involved in a shootout. In another instance, you had possession of the firearms in Mr. Amerson's home. So the underlying facts are very, very different. Here we have a mere 2-week difference. We have 2 pistols, different weapons to be sure, but both pistols. So I'm not sure how helpful Amerson is to the argument that the defense is making, given the different facts that we have. And finally, Your Honors, you all started out with the assumed error harmlessness issue, and I think that's a very significant point, because in its assumed error harmlessness discussion, the district judge talked at length about the 3553 factors. The district judge was deeply concerned about Mr. Huff's recidivist tendencies. As the record shows, he had a prior conviction in the Eastern District of New York for a Hobbs Act robbery. That Hobbs Act robbery involved Mr. Huff kicking and pushing an elderly man to the ground when they robbed the jewelry store. And we understand the fact that he got a lenient sentence because of his extensive cooperation. But I think what concerned the district court is that despite leniency, despite being indicted in federal court in New York, despite being convicted of a Hobbs Act robbery and getting a lenient sentence, he's not deterred because he immediately returns to a life of criminality. So it is on that basis, again, putting aside this 4-level enhancement, when you look at the assumed error harmlessness, when you look at the record that was before the district court in terms of why it varied upward, if you're going to look at this as a variance as opposed to an upward departure, it was his criminal history, his recidivist behavior, his repeated convictions for misdemeanor offenses, felony offenses, repeated failure to abide by the conditions of supervised release, of parole, that sort of thing, that's what was driving another theme, if you could say, that was driving the court's decision to impose the sentence that it ultimately chose to impose upon Mr. Huff. And Your Honor, we haven't touched very much on this question of criminal history. You know, as part of the departure, there were two pieces of it. There was the upward departure based on 2K2B6B for use of this firearm in connection with another offense, but there was also the upward departure based upon the inadequacy of the criminal history. I've spoken at some length about this 2010 Hobbs Act robbery conviction in the Eastern District of New York, but there are other convictions as well, and sort of a series of antisocial criminal conduct that kind of continued all throughout Mr. Huff's life. And in view of that, the district judge, we contend, did not abuse its discretion by varying upward to the sentence that it did in view of that criminal history. And Your Honors, I still have some time, but I didn't have any additional points to make. But I did want to say, if there are no questions
you
at this point.
You don't have to use all your time.
All right, Your
Honor. Lawyers like to sit down.
Well, Your Honor, the final point that I would like to make is that I do think that that the district, when you're looking at the assumed error harmlessness argument, I do think the district court's findings on that are owed some deference. And the court at length, I mentioned already the criminal history, the court talked at length about the need to incapacitate Mr. Huff, and the district judge said that it was a, quote, certainty that Mr. Huff would reoffend. And so I think when you look at all of that from the assumed error harmlessness standpoint, I think the district judge did not abuse his discretion. I believe that his decision to depart upward is due some deference as we look at it in this forum. And I also think, going back to the issue of the upward departure, again, looking at the pieces of the evidence, and again, evidence can always be contested. There's always a different argument to be made. That's what litigation, that's what the adversarial process is all about. But when you do look at the evidence that the district court had in front of it, I don't think it can be said that it was clearly erroneous for the district court to make the findings that it did, based upon the evidence that was in front of it. So,
Mr. Ricky, just to ask you a couple of factual questions. So, what sentence did the government seek below? Was the district court's sentence consistent with that which the government asked for?
It was, Your Honor. It was 663 to 78 months is what the new guideline was, and the government had asked for a sentence within that new guideline.
And what was the statutory maximum?
It's 10 years, Your Honor.
Okay. Thank you.
Thank you, Your Honor. If there are no further questions from this court, in summary, I would just ask the members of this panel to affirm the judgment of the district court and appreciate your attention to this matter. Thank you.
Thank you, Mr. Ricky. We appreciate it. Ms. Tarleton?
Thank you, Your Honor. A few brief points. As the court is considering this case, I would urge you to consider what the effect of a ruling in favor of the government in this case would incentivize, and ask yourselves, is there a floor as to what can come in as relevant conduct in these sentencing hearings? Here we know that there's at least one clearly erroneous factual finding by the district court, and it's a significant one that would indicate consciousness of guilt, and that's disposal of the weapon to obtain another weapon. At JA 99, that has no factual support, and I think it's very concerning to infer that if the district court already believed that Mr. Huff had committed the murder, it was okay for him to infer that he had then disposed of the weapon. I think that gets it exactly backward. I would ask this court to consider that this is an incredibly serious
Can I ask a question about that? So with respect to that finding, if we were to agree with you, could we simply just set that aside and say, based on the balance of the record evidence, that the finding with respect to your client's culpability, ultimate culpability for the shooting, is unchanged, and so that error is harmless.
I don't think so, Your Honor, because we don't know that from what the district court said on the record. We don't know what exactly caused the district court to believe that Mr. Huff committed the shooting, but in fact, that is the one thing that he cites at JA 99 in support of his conclusion that, quote, the defendant, Mr. Huff, did shoot Mr. Boyd on April 23, 2018. The next sentence is, he was not in possession of that gun on May 8, 2018, but he was in possession of another gun because he was aware of what he had done on April 23, 2018. He didn't cite to Mr.
Carlson, I think perhaps a fair inference of that is that there's sort of the district court supporting his finding with respect to related conduct by tying those two incidences together, the throwing away of the weapon and the purchasing of a new one. But that's separate from the finding of whether or not Mr. Huff actually committed the shooting. Those are two separate things, aren't they?
I disagree, Your Honor. I think, as I mentioned, I do believe if it were proven, it would be evidence of consciousness of guilt. And the fact that it directly follows the district court's conclusion that Mr. Huff did shoot Mr. Boyd is significant. The district court doesn't cite the statements or identification made by Mr. Boyd. That is not sort of what is motivating, at least based on this record, its determination that Mr. Huff shot Mr. Boyd. And so I don't think that this court has sufficient basis on the record to say that that clearly erroneous factual finding is in fact harmless. Again, if the district court believes that it can justify its sentence based on other factors, it's free to try to do that on remand. But I think that this court at least should give the court the opportunity to revisit that conclusion with the knowledge and the understanding that there was no evidence presented in the record to support it. I would also ask this court to consider that a shooting and murder is an incredibly serious offense that's being swept in to enhance a much milder offense of felon in possession of a firearm. And in that context, I think that the court needs to be particularly diligent about what kinds of evidence is presented. Here, I know the court asked about the cell phone records. Those records were not introduced in evidence at the sentencing hearing. And in fact, the testifying witness, Agent Baer, hadn't even seen them. So he believed that they showed that Mr. Huff's cell phone was at the scene, but he hadn't seen them himself. He hadn't seen the photographic lineup himself. He didn't interview any of these witnesses. He didn't interview Mr. Boyd. He didn't interview Mr. Huff. And he hadn't even seen the firsthand statements made by any of these witnesses. And on this thin of a record, I think that this court is bound to vacate and remand for resentencing, if for no other reason than to ensure that when these relevant conduct analyses are conducted, they are conducted with some integrity and with sufficient indicia of reliability to justify enhancing someone's sentence by triple what the advisory guidelines would otherwise recommend. So I would urge this court to think carefully about the consequences of a ruling in the government's favor in this case, and to, reinforce that even if the standard is lower than it is in a criminal trial, it still has teeth, and that those minima must be met before the district court is entitled to enhance a sentence. So we would ask this court to vacate and remand Mr. Huff's sentence.
Thank you very much, Ms. Carlson. We appreciate it. Your case will be submitted.
Thank you, Your Honor.
Madam Clerk, we will take a brief pause, and then we'll proceed to the third case.
The court will take a brief break before hearing the next case.
Conference recording.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Our third case of the day is number 19443, In re Torrance. Mr. Bondurant?
Yes, sir. Good morning, Judge King. Good morning, Your Honors, and may it please the Court. My name is Joe Bondurant. I'm here.
Go right ahead.
I'm sorry. Yes. My name is Joel Bondurant, and I'm here this morning on behalf of the movant, Mr. Torrance. And the question presented in this proceeding is whether the recent 2254 petition that Mr. Torrance submitted to the court in November of last year is a second and successive petition such that he needs permission from the court to file it. We submit that under the governing analysis, which considers whether or not Mr. Torrance has engaged in abuse of the writ, yields the conclusion that Mr. Torrance has not, in fact, been abusive of the writ and does not need permission, and this is not a second or successive petition. Mr. Torrance was initially convicted.
Pardon me for interrupting. I have a procedural question for you.
Okay.
Did you actually file this petition, which you claim to be a not successive, but another continuation of the original first petition in the district court?
Did not. No, I was appointed as counsel once it got to the Fourth Circuit, and I was not involved in any way in any of the lower court proceedings, and I don't know that it's been filed in the district court currently.
Well, the reason why I asked that is I'm kind of puzzled with this case because the basis for jurisdiction, as you point out in your brief, is for our jurisdiction is 28 U.S.C. 2244, which, as you candidly point out, deals with successive petitions, and of course you claim that this is not a successive petition, and you may well be correct given all the steps that your client took to try to preserve the claim in the district court the first time that his other claims were being considered. But it's just not clear to me what jurisdiction we have to consider this claim or rule on this issue if the district court has not been given an opportunity to give a thumbs up or thumbs down to your claim that this is in fact a first petition, so it doesn't require authorization from the circuit court. So what's your response to that?
Well, Your Honor, that's an interesting question that I had not considered. I think that obviously Mr. Torrance filed this request for authorization as a pro se matter initially. I don't think at the time that he filed it he realized that he had what I believe is a strong argument that it's not a second or successive petition, and I think there's a case law in other jurisdictions where the court, I guess I'll answer it this way. I don't know. Since the court has jurisdiction to consider this issue of 2244, there's necessarily sort of a gatekeeping question of whether, in fact, it is subject to 2244, and I don't know how we ever make that determination without assuming jurisdiction over the case for purposes of making that determination. And the other cases that
sort of the way to do it, I would think, is you would file the petition in the district court, obtain a ruling from the district court. Yes, it is an initial petition, a proper first petition, in which case there's no need to appeal, and the petition is considered on the merits, depending on what the government says in response. Or if the district court rules against your client, then at that point it seems proper to come up on appeal to our court. But I mean, as it stands right now, we're essentially, I think, being asked to give an advisory opinion as to an issue that has not yet been fully joined, because no one has said, no district court has told you or your client that you can't file this petition.
Right, yeah, and I certainly understand the issue and appreciate the question. And it's, again, I think the answer is that the 2244, this court has to pass on the question, I think, of whether it's a second or successive. In other words, I don't know that there's any necessary...
We do. We have to pass on the question of whether it's second or successive if someone tells us that it is, because in the typical case, the petitioner is seeking permission for us to file a second, for him or her to file a second petition. But this is a very strange case because you're saying this is not a successive petition, and you're asking us to opine on that, and what I think is a very odd procedural posture. But I've expressed my concern, and we'll just go on and move on. But I hope you understand what the concern is that I have.
Mr. Bondurant,
yes.
Mr. Bondurant, this is Judge King. You're asking for permission. Would it be fair to say if you need it? And if you don't need it, you'll leave it to us to say so.
Yes, Judge King. I think that's another way
and you'll go to the district court. Or if we say what you want us to say, and this is a position, I think, a legal position that you, as his counsel that we appointed, you were appointed by the Fourth Circuit Court of Appeals, and you say he doesn't need any permission. He can go to the district court. If we agree with you on that, and the government doesn't agree, as I understand it, if we agree with you on that, you're going to go to the district court. If you do that, are you going to go with him? Who's going to represent him then? Is he going to be pro se again?
Judge King, I believe that he's going to, in all likelihood, be pro se again, or may get appointed counsel at that level. I had not, planned it at that.
You're only appointed for the purposes of this proceeding, correct?
Yes, sir. Yes, sir.
And so you've taken the position as his lawyer. I assume, and you got him to go along with it, or advise him of it or something, after you got appointed, that the circumstances of this proceeding are such that he does not need permission to file this proceeding because it's neither second nor successive.
Right.
Okay. I didn't mean to interrupt you.
No, that's okay. It's a good question, and I appreciate the clarification. But that is in essence the argument.
Right. I'm not saying I'm right. I'm just saying that was my perception of it after I've looked at what we have before us here. And,
right. Yes. And you're right. I mean, in terms of your perception of what the argument is and the presentation and the issue, and of course, as you noted, I was appointed just in the appeal process when he presented his pro se petition to the court seeking the authorization. Like I said, I don't think at the time he had any idea that he might not need it. I thought that he thought he was going to need it under 2244, and the Office of Staff Counsel likely reviewed it and thought there was something there. And he
presented. So he filed it as in the Fourth Circuit pro se, and the Fourth Circuit appointed you, and you filed some papers for him and filed briefs, and we set it for argument, and it's up here.
Yes, sir. That's exactly what happened. Yes, sir.
And if we rule the way you want us to, he can go back to the district court or go to the district court and show him whatever papers he gets out of the Fourth Circuit to go with his petition, I guess.
Yes, sir.
Mr. Bondurant, I don't beat that horse here, but one of the first things we need to consider is our jurisdiction, and the statute 2244 B3C, I think it is, says that the court may authorize the filing of a second or successive application only if it makes the required determinations. It doesn't say anything about a court being asked to opine on whether or not a petition is successive in the first instance, and that's the concern that I have. Now, we have on occasion indicated when a petitioner files a motion for permission, we haven't, I guess, on some occasions said that if a petition is pending down in the district court, he doesn't need permission because the petition is pending in the district court. And maybe this is just an offshoot of that. But in any event, go ahead. We spent enough time on this.
No, I want to follow up on that too, though. I'm with you, Judge Diaz, and I'm not sure we spent enough time on it. But I do think that in line with what Judge King is saying and your jurisdictional concern, essentially the remedy that's being asked, it seems to me, is to simply dismiss this as unnecessary, which you dismiss when you don't have jurisdiction. So I think ultimately that would be what would be asked for here, because if I recall, there was a petition that was filed in district court in 2019, but there was no ruling by the district court because you filed this 2244 motion here with the Fourth Circuit. And so when we get something we don't have jurisdiction over, whether for whatever reason, if it's unnecessary, I think simply you just dismiss it. And then that gives you leave to go in particular if we dismiss it as unnecessary.
Mm-hmm. It seems to me that this Judge King again, it seems to me that I have been involved in proceedings such as this, in which we have done just what Judge Wynn mentioned, and there's got to be records of them in the Fourth Circuit, and maybe even had them as a single judge. But anyway, I've involved proceedings like this.
Yes, sir, Judge King. And to follow up on the points Your Honors are raising, if you look at the way the primary case we rely on, the Martinez case, if you look at the way it's analyzed, what the court ultimately ends up saying is that this is not really multiple petitions. This is really all one petition that had multiple claims, and he's entitled to an adjudication of every claim. And to get back to Judge Wynn's point, this claim was filed originally in 2005 as part of the initial petition and was then subsequently dismissed because it was had not been exhausted. And so this newest nothing has been filed in 2019 in the district court that I'm aware of, but there is the
only thing that's been filed in the district court's the 2005, correct?
As far as yes, that's correct. And
getting back into papers now. 2005 we filed it, and then it was dismissed with a request after you asked for a stay. He did. Stay in abeyance, and that was denied. So he dismissed count 11. That's right. Count 11. And count 11 had not been exhausted, and now he's exhausted 11, and it's and that's why it's back up. And that's over with. He says he's going to litigate it again. But there was something filed. It was dismissed in 2018, or he finished exhausting in 2018, and he filed this petition, I guess it is, in 2019.
That's right.
But he filed it in the Court of Appeal. That's the point that Judge Diaz is making. He may have filed it in the wrong court. I don't know.
No, I understand.
But he doesn't have to if he wants to get. But we're the only one that can rule on whether it's second and successive. And if it is second and successive, we got to give him permission.
I believe that's correct. And if it's not second and successive, I believe you do something along the lines of what Judge Wynn suggested, or perhaps even what Judge Diaz was suggesting, which is you say it's not second or successive, therefore we don't have jurisdiction. And he doesn't need the authorization, but he's entitled to an adjudication of the claim that was properly filed back in 2005 under.
And then you're going to have to go back to. Then you're going to go back to the district court, and you're going to have to probably litigate whether there's a statute of limitations that was told or something. But anyway, that's another matter.
Yeah, I anticipate that's probably be an issue. In fact, the government raised it, and
that's one of the reasons I was asking you if you were going to stick with him. I mean, maybe you may have a lawyer obligation to stick with this fellow. Might be like
that's something. Yeah, that's certainly something I can discuss with him and with the court and do whatever needs to be done. Certainly. And I heard a sound in my ear. I don't know if that's my time up or not, but that's.
If that's your time's up, we sure took it all for you.
That's all right. That's what I'm here for, to answer questions.
Madam Clerk, does he have some more time?
He has 3 minutes or 7 minutes for rebuttal. Sorry.
You want to take?
Okay,
I'll give you a couple more minutes there. Go ahead. I'll take it upon myself to give you 2 more minutes, Mr. Bond.
Sure. Thank you. Thank you, Judge King. Yes, thank you, Judge King. I won't take too much time. I can see that certainly the jurisdictional issue is the one that the court's grappling with. I think that, I presented the substantive arguments as well as I can in my brief, and I think the court very well astute on what those are. I don't think that there's any abuse of the writ. Mr. Torrance did everything he could to try to streamline the proceedings and keep it all in a single habeas proceeding. So there's really no way to argue there's an abuse of the writ. The only way I think that he might encounter difficulties is if he steps in some type of procedural snare, like the jurisdictional problem potential jurisdictional problem we've been discussing. But I don't believe it's really a problem that needs to hold the court back. The court, if we take it outside the context of where we are now and just think of a subject matter jurisdiction motion, for example, the court has to make a ruling on subject matter jurisdiction, even if it ultimately concludes there is no subject matter jurisdiction. It has to sort of set forth its analysis on why and issue a ruling like that. And this would be very simple.
Bondurant, can I ask a question finally on the merits?
Sure.
So can you think of any other way that your client could have preserved this issue, I mean, other than what he attempted to do in this case?
I don't think so, Judge Diaz. If you look at the way it played out, the allegation is that the Department of Probation and Parole changed his eligibility status in June of 2004. He almost immediately thereafter started his ALJ proceedings in the state court, and within several months started a state PCR proceeding, and within a week of that filed the 2005 federal PCR application that we've been discussing. He flagged everything at that time in terms of the exhaustion requirement and the pending proceedings in state court to meet that exhaustion requirement. And he asked for a stay of the proceedings, which I think, frankly, probably should have been granted under the Ryan C. Weber case, but there's no indication that was considered. But it probably should have been granted, and then we wouldn't have this problem before us today. But I think we did everything we could to preserve it.
You could have done. He could have tried to appeal the denial of that stay in abeyance.
Well, and there was an appeal, and I don't know that issue was raised, but you're right.
Well, he asked for a stay in abeyance as to that count 11, and it was denied for some reason, and he left it like that. He didn't make an effort to appeal. Now, whether he could have done anything on appeal, I don't know, but he didn't try to appeal.
I certainly agree with that, Judge. I would just fall back on the governing analysis, really, which is, is that enough for us to say he's abusing the writ? Because that's the real question we've got to answer on whether or not this is second or successive and whether it needs authorization. Is he abusing the writ? I don't think we can simply say, based on that fact alone, that maybe he could have appealed that procedural ruling on the stay is enough to say he's abusing the writ. I mean, I think if we look at it objectively, he did, with the exception of maybe taking an appeal, he did everything he could to streamline that proceeding and keep it as a single federal PCR proceeding. And I just don't, again, under the governing analysis, just don't see how anybody could objectively say that he abused the writ. But that is the fact that you brought up there about the appeal. I guess that could be something on the scale against him. Perhaps.
Well, maybe I find an idea here with the state lawyer. But if your time's up, we'll see what he has to say about it. And then you have some rebuttal time, right?
Yes, sir. Thank you.
Thank you, Mr. Bondurant.
Yes, sir. Thank you.
Now, I've lost my place here, counsel. You're going to have to get going on your own. Let me see. Mr. Buchanan.
Yes, Your Honors. Judge King, Your Honors, may it please the court. Matthew Buchanan with...
Mr. Buchanan.
I beg your pardon?
No, you're counsel for... who do you represent? Identify yourself.
Okay, yes. I'm Matthew Buchanan. I'm general counsel with the Department of Probation, Parole, and Pardon Services in South Carolina, representing the state.
All right. And he's Mr. Torrance is a South Carolina president. I'm with you.
Yes. All right. Well, to begin with, I certainly acknowledge the fact that there's this jurisdictional question, but it's the state's position that this is second and successive. This clearly then falls under 28 U.S.C. 2244, certainly B1, where a claim is presented that was presented in the prior application shall be dismissed. The language is very solid. There's no discretion. Does not have to say that the case was ruled upon or the matter was ruled upon. It just says it was presented, which in fact it was. Yes, then it was dismissed. We would say that, there certainly was that, as Judge Diaz pointed out, could have been appealed. That was not. I think it's a big assumption that to say that they simply withdrew the case, that particular claim, Claim 11, because they had no other choice. That's not really supported by the record. It could have been an attorney decision because the attorney recognized that it was meritless.
I thought he was pro se. I thought he was pro se.
Well, yeah, it was it was raised pro se. That it was included in a pro se appeal, but then he was represented by counsel. He was appointed counsel, and then that counsel later on dropped that particular claim. Obviously, it was not ripe yet, but we could also just as easily assume that it was not.
It had not been exhausted.
Correct.
It had not been exhausted, and he asked for a stay and abeyance, which the Supreme Court case says that's the way he's supposed to do it. And then he decided to proceed on the other 10 counts and set that one aside and dismiss it.
Correct.
Now he wants to come back and you say that's second and successive, and Mr. Bondurant says it's not second and successive. So that issue is joined here. Now, if we disagree with you, and do we just dismiss it, or what do we do?
Well, if you disagree, then I'm assuming that he will eventually try and file that claim in the district court. But particularly for judicial economy, I think it's appropriate to rule upon whether or not it is second or successive now, because obviously if it is second or successive, then you might as well rule that it's a prior presented claim and therefore should be dismissed.
Well, if it's not second and successive, he needs to get the Court of Appeals to say so. He has to, under the statute, doesn't he?
Correct.
Okay. So if he can get the Court of Appeals to say that it's not second and successive, then he can do as Mr. Bondurant says. He can go to the district court and proceed, and then you can litigate there with him and on whatever issues you want to raise.
Mm-hmm. That's correct. Now the issue though, because certainly Mr. Bondurant is leaning hard on the abuse of the writ principles, but as we've seen in McCleskey v. Zant, those fall under equity principles. So he's got to come to this with clean hands.
And that's the standard for determining the second successive issue?
Precisely. And that's part of the point that I made in my brief, is that he is actually arguing something counter to what he argued at the sentencing court, because he argued during sentencing at the trial court, he argued that he was not parole eligible.
You're getting into sentencing, and that's not in this record.
There was a supplemental.
This record, all we got here is a petition.
I believe that I offered a supplemental record that points out in the move-ins pretrial brief, page 104 and 105 in our reply attachment number 2. That was because he was facing a death penalty trial. During sentencing, he or his attorney argued that he was not parole eligible, and he should therefore be, or the jury should be told that. And then the judge ruled that he was parole eligible, and did not present that fact to the jury. Now, it ended up being a harmless error, because the judge erred when he did that, because that was contrary to statute. And we can know that this was an error because his co-defendant, also happened to be his brother, was in fact sentenced to death, and then that sentencing was overturned in Torrance v. State, State v. Torrance, because the judge erred and ruled that he was parole eligible. So here we are. Now he's trying to take advantage of that judge's error by saying he was parole eligible when, in fact, the statute clearly states that he was not parole eligible, and that was the ruling of the Department of Probation, Parole, and Pardon Services back in.
Mr. Buchanan,
yes.
That sounds like a merits argument, though, not relevant to the question of whether or not this is in fact successive. I mean, the district court can sort that
right.
out, right?
I submit, though, that this goes towards the clean hands of the equity principles of the abuse of the writ. That's why I submit that this is relevant.
Do you have anything else, Mr. McKenna?
Well, beg the court's indulgence. I believe ultimately, I think I'll go ahead and I'll sum up if there's no additional questions by saying that.
I do want to ask you a question about something.
Oh, sure.
To contradict a fact that seems clear on the record, and that is whether or not this petitioner actually requested a stay in the district court during his first go-around on his initial petition. You seem to suggest in your brief that he didn't, but he clearly did. So I'm not sure what you were getting at. Maybe you can explain that.
I might have inartfully talked about him not appealing that stay, but I certainly acknowledge the fact that he did, in fact, try to try to ask for that stay, and that was denied.
He preserved the issue that he made a record. He asked for a stay and abeyance,
mm-hmm.
and it was denied.
Yes, that's my understanding.
And he did not seek to appeal. Now, whether he had a right to seek to try to appeal that, I don't know. But you said, and I agree with you, he didn't try to appeal. Whether that makes any difference here, I don't know.
Well, I think that kind of goes along with the argument that I think it's an assumption to make that the case was simply just abandoned because he didn't have any other choice. I mean, I think it also very well could have been withdrawn partly on the merits so that they didn't tie up the remaining rights. And
in fact, he said that he was pursuing the issue raised in Count 11.
Yes.
In the administrative law court in South Carolina, and he gave the file number, and he was pursuing it in a state court in South Carolina, and he identified that with the file number. So he was pursuing it in an effort to exhaust the Count 11 claim. And he finally, according my recollection is that exhaustion wasn't consummated until 2018, and that's resulted in these proceedings that we have here now, where he wants to come back with what was Count 11. And you say it's a second successive petition, and Mr. Bondurant says it's not. And that's the issue that we're faced with. That's the only issue we're faced with that I can see.
Correct.
Is it a second successive?
And I would submit that it is, in fact, second and successive. We do have some evidence to show that this was not purely a clean hands equity abuse of the writ, simply because he's arguing something that he counter to what he argued at his original trial. And the statute is
you're going back to the trial on the criminal offenses that got him in penitentiary down there, right?
Yeah.
Using him unclean hands on this second successive thing.
Right, because he is now arguing something counter to what he was arguing before the trial court, and is trying to take advantage of a very clear error of the judge in saying that he was parole eligible when in fact he was not. The statute 2421-640 is very, very clear, stating that parole is not authorized, nor shall parole be given to someone serving a second or subsequent office.
You want us to get into the merits, and Mr. Bondurant says we can't get into the merits. We got to decide whether this is second successor.
I apologize. It looks like Mr. Bondurant has dropped off the call, so I'm going to go ahead and pause and add him back.
We better give him back. That's right.
That's it.
Mr. Bondurant, welcome back. Mr. Buchanan, go ahead.
All right, thank you very much. So you were asking that it seems like I'm going into the merits, and I'm only pointing out these things for the context of the abuse of the writ matter, as well as the assumption that the count 11 was withdrawn solely because it was still pending in the state court. That's an assumption. That is not something that we know for sure, because and it could have been a tactical decision by the attorney who was appointed, withdrawing it because it was meritless. So that's something that we don't know. It's not supported in the record how or why that attorney came to that decision to withdraw rather than appeal the denial of the stay. So therefore, we would submit that this is a second or successive second or successive petition, and the abuse of the writs principles do not apply regarding the argument that it is simply a continuation of the existing petition.
Very good.
All right. Thank you very much.
Judge Wynn, Judge Diaz, y'all have further questions?
No.
I do not. Thank you.
Okay, Mr. Bondurant?
Yes, sir, Your Honor. Thank you. I really just got two quick points I want to make in conclusion, and certainly free to entertain any questions. But the first is this notion of why Claim 11 was abandoned. I think it's fairly strongly stated at page 74 of the Joint Appendix, which is the court's order, in footnote 1, says, at the time the R&R was issued, the petitioner was in the process of pursuing an appeal of a decision of the probation, as well as a second PCR, which was pending before the Court of Common Pleas, etc. So even the court order that dealt with this back in 2005 acknowledges that the reason that count was abandoned was because of exhaustion concerns and the fact that it wasn't exhausted. So I just wanted to note that the record does contain evidence that was the real reason for the claim not being pursued at that time. The second point that I really want to make is to return to this notion of jurisdiction, and because that's obviously a very, very heavy concern on the court's mind. But I think that the way it works, if you, I'll just use the word craft, but take it in the spirit in which it's meant, I think the way that the opinion would sort of be crafted would be, if the court thinks there's no jurisdiction, is to say, movement has sought authorization under 2244. We don't think that this is second or successive under these authorities, these Supreme Court authorities, and that he doesn't need he doesn't need the authorization, is entitled to adjudication of all claims raised in the original petition as stated in the Martinez case. Therefore, since this is not a second or successive petition, we dismiss the case for lack of jurisdiction. I mean, I think there are multiple ways to get to the end result of ruling on the case, but it's not at all uncommon for courts to have to rule on those types of arguments in all types of circumstances where their subject matter jurisdiction is raised is at issue. They have to sort of make the preliminary determinations on whether they are or not within the subject matter jurisdiction. And if they're not in this case, I think that very analysis carries with it this notion of whether or not he's entitled to have the adjudication, because that's the whole point of saying that it's not second or successive. So I don't think that the jurisdictional issue, while I certainly understand, the court's concern and the court's insistence on, protecting its own jurisdiction and raising proper jurisdictional issues, I just don't think that that's an impediment to ruling on these issues, these arguments that have been presented. So, with that said, that's all I've got.
Mr. Bondurant, can I ask you a question related to your colleague's arguments dealing with what Mr. Torrance may or may not have said at the penalty phase of his trial?
Yes,
you have a response that his argument is that, well, it's not really a merits argument because the whole basis for your asking us or asking the district court to entertain the petition is not an abuse of the writ for all the reasons you explained in the argument, but that we should in fact consider. Who's shuffling all those papers? I'm having.
Somebody's shuffling. There we stop.
Okay. But you're.
There they are again. Whoever it is, you need to stop it or put on your mute button.
I'd like you to respond to this issue of whether or not we should consider that information, and if so, whether you have any factual rebuttal or just think that it's just premature at this point.
Yes, sir, Judge Diaz, thank you. I do think that it's factually premature at this point, but I don't want to stand on that ground alone. I don't know that the abuse of the writ doctrine or the analysis is that sweeping in terms of all the equitable concerns of all time being brought within it. I think if we look at like page 17 of my brief, for example, I've got a block quote from Sanders versus United States, which is a U.S. Supreme Court case, which talks about the types of things we're looking at when we talk about abuse of the writ in this context. And what we're talking about generally is people doing things, petitioners doing things that are sort of intended to undermine the streamlining of the process. I mean, that's what the whole Effective Death Penalty Act was about, was trying to give effect to state court judgments, because PCR petitioners were dragging these things on indefinitely by doing, they'd file one claim, and when it was denied, file another claim. So the whole point of EDPA was to force them to bring them all in a single proceeding. That's the abuse of the writ that the statute was meant to address, and that's when you read the case law, what the cases say in terms of how you do the analysis and what it's meant to remedy. So I don't think that there's any, I don't know of any authority that says that any and every equitable concern, however couched, might be relevant to this analysis. I just think it's a question of, was this guy abusing the writ, or was he not? And I think under the applicable analysis, he plainly wasn't, because he was trying everything within his power to actually streamline the proceedings, to keep it all in a single proceeding, and that's what the abuse of the writ is concerned with, not just general equity in some ubiquitous sense.
Okay, thank you.
Yes, sir.
Mr. Bondurant, I want to tell you, we appreciate your efforts as court-appointed counsel, and we need lawyers like you that will come in and do this. And who did you clerk for on the Fourth Circuit?
Judge Traxler.
It's Traxler.
Sure. Judge Traxler, yes, sir. And in fact, it's been a long time, Judge King, but you and I and some of your clerks, I think Maggie was one of your clerks back then. You and I, and you have no reason to remember this. It's been so long ago, 20 years ago. You and I and some of your clerks would go down and grab dinner together, but that's been a long time ago.
I thought I had a vague memory. Anyway, we appreciate it very much. In this case, will be taken under advisement. And Madam Clerk, we will take another break, and then we'll go to the last case.
Thank you, Your Honor.
The court will take a brief break. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Our fourth case of the day is number 19-1202, Capital Finance versus Rosenberg. Mr. Doherty?
Yes, Your Honor.
Good to have you with us, sir.
Thank you for allowing us to appear by phone, Your Honor.
Yes, sir. You may proceed.
Oh, thank you, Your Honor. May it please the court, my name is Colin Doherty, and I'm one of the attorneys who represents appellants Joseph Newman and Oscar Rosenberg in this matter. Mr. Newman and Mr. Rosenberg are two personal guarantors of a loan that were issued by Appellee Capital Finance to a number of business entities referred to in the briefing as the borrower. It was a collection of 8 nursing facilities that received funds, among other places, from Medicare. At a bench trial that occurred over 2 days in front of Judge Bennett of the District of Maryland, rulings were issued by the court that reviewed by Mr. Newman and Mr. Rosenberg to change a key and critical element, the word and read it as the word or, instead of in the normal, customary, and usual conjunctive form of and. This critical change then allowed the court to find liability on behalf of the personal guarantees against Mr. Rosenberg and Mr. Newman, and created liability that now exceeds $1.3 million against these two guarantors. There is no reason and no explanation, no valid explanation for changing this unambiguous term in the contract, and it goes against longstanding Maryland contractual interpretation to do so. Notwithstanding that,
Mr. Doherty, excuse me, this is Judge Diaz. I think you appropriately conceded that this issue with respect to how to interpret the conjunctive and is not absolute, that there are exceptions to the traditional meaning of what that conjunctive means in the normal course of conversation. And from the district court's perspective, it observed that your clients were in essence arguing that they were free to commit fraud or other illegal actions with no liability on their personal guarantee, and he couldn't countenance reading that language to allow for that really incongruous and, frankly, from this perspective, absurd and unrealistic result. So, I mean, that seems to make sense, but what is your response to that?
Well, Your Honor, with all due respect to the trial court, we disagree. These were limited personal guarantees, and
well, you're right. They were limited, but they weren't intended to be toothless.
I understand, Your Honor, and I agree with that. What they did was create a situation that does not allow the guarantors to openly commit fraud. It allows allows Capital Finance to seek monies from the personal guarantors if those 3 issues happen, which are possible to happen together at the same time. Otherwise, the Capital Finance would be limited to the borrower, who is the signator of the loan. This comports with sort of traditional notions of the corporate entity. It also, unlike the cases relied upon by the court, with all due respect, we disagree that it creates an absurd result. What it does is create a situation where, through bankruptcy filings, and then in addition to a potential fraud or illegal act, the lender would not have another recourse because of the bankruptcy of the borrower or the borrower and sub-entities, and would then have to seek recourse from the personal guarantors.
Now, you did provide an example, I guess, of a possibility of a party both colluding with other creditors to cause an involuntary bankruptcy and at the same time filing a voluntary bankruptcy, but you literally have to tie yourself up into a pretzel to make that happen. It just seems illogical to me that those two things would happen in the normal course of affairs, and even more logical to think that someone who is attempting to maximize its ability to recoup on a guarantee would intentionally agree to that kind of a provision, which effectively makes the guarantees meaningless.
Well, I'm sorry, Your Honor, would you like me to respond?
Yes.
Well, so I think, though, consider, though, the borrower as a single entity creates a more difficult situation, a less likely situation for these multiple things to happen. But when you consider the borrower at what it really was 8 different entities, it increases the likelihood that the various issues could occur. Additionally, the parties agreed to this writing, including, a sophisticated banking entity, and never admitted on the record that prior to this court hearings, this issue was never discussed.
So you're talking about the trial when you say court hearing?
I apologize. Yes, Your Honor.
Okay.
So to say that the Capital Finance intended something different than what is written on the paper assumes that, quite frankly, a sophisticated banking entity made a mistake, and they've never argued that, nor offered evidence to that effect. In fact, throughout the trial and the briefing in this manner, the appeal, they have taken the position that the contract is unambiguous, and in fact, the trial court found the same. And we certainly struggle with the idea that using "and" in the disjunctive in this one spot in the contract, when it is always considered in the conjunctive throughout the entire contract otherwise, and "or" is used in the disjunctive throughout the contract otherwise, could be anything but unambiguous, or if it is unambiguous, as the Capital Finance concedes, then it is unambiguously used in the conjunctive and means exactly what it usually and historically customarily would mean, and that is all 3 events need to occur, which are possible to occur.
This is Judge Wynn. So we are under Maryland law, and the Maryland Court of Appeals has recognized that those terms "and" "are" can be used interchangeably when it is reasonable and logical to do so. And here you have an instance of, here are the 3 events: improper voluntary bankruptcy, improper involuntary bankruptcy, and fraud or illegal behavior. Can you tell me one case where you've seen all 3 of those occur?
Your Honor, I am not aware of any one case where that.
Tell me of any instance that you realize from your practice where all 3 of them have occurred.
I'm only aware of the Caesars case that we cite where the first 2 occurred, but I certainly am not.
That wouldn't do it under your scenario. You need all 3. You need an improper voluntary bankruptcy, an improper involuntary bankruptcy, and fraud or illegal behavior. What in the world makes it logical that those 3 have ever occurred, or the likelihood that it would occur?
Your Honor, we will certainly concede, as we did a trial, that it is unlikely. It is
How
not.
about illogical?
Your Honor, I can't speak to what was in the mind of the
What's
draft.
in your mind on it, though? Don't you think that's illogical?
Your Honor, I'm not a sophisticated banking entity. I think when
well, we're kind of the sophisticated folks here. We have to determine what's reasonable and logical in this contract. I'm trying to follow the logic of the argument in light of Judge Diaz's question, followed by Judge King. And when we look at those three things occurring, I don't know how one can say you got to have all three, because no one, not even you, can tell me an instance where all three, and I ask not only for cases, but in your experience, where all three have occurred.
I understand, Your Honor, but it is a limited personal guarantee. The purpose of a personal guarantee is...
I think it's no guarantee. It sounds like it's no guarantee. If you've never seen it happen before, then it's nothing. Don't you think? I mean,
issue for the trial court. It was a trial that the court, Judge Bennett found against you as a matter of fact, didn't he?
Your Honor, the standard review on interpretation of a contract would be a de novo before.
No, but he made findings about this and or as after the trial. He heard evidence and then made findings and conclusions, and are all adverse to you. Why wouldn't it be reviewed for clear error?
Well, any factual findings would be reviewed for clear error, but any legal conclusions would be reviewed de novo.
I know. I understand those legal principles, and I'm saying this is a factual finding, isn't it?
That there was an error. Well, quite frankly, we take exception with Judge Bennett's ruling because we can't get it to square in that he found that it should be read disjunctively, but that the contract was also unambiguous. Which is also what Capital Finance has argued.
Mm-hmm.
And our point being that
and the dis-and in that clause there cause your people not to pay the taxes.
It did not.
Money in the wrong, and put the money in the wrong accounts.
Your Honor, it was the third-party payer who directed the money to go to the other accounts. And then the tax, as we pointed out in our brief, the tax monies were due before a penalty would incur, and we were inside that time frame before the penalty accrued. Even though that acknowledged that the taxes were not paid when specifically due.
These were withholding taxes of employees, right?
Yes, they were.
They're trust monies. I mean, they stole the taxes from the employees instead of paying them over to the government.
Well, with all due respect, Your Honor, we would take exception with the use of the term "stole," but they had not paid.
I'm sure you would, but I used to be a prosecutor. I've had a lot of cases like this. I mean, a lot of cases of people messing with these withholding taxes. We used to have crusades to go after them.
And the impetus of what Judge King is saying here in terms of the factual finding is you do have a different opinion in terms of how to look at this, but the question before us is whether there is clear and convincing evidence to support those findings that the trial judge made. And here, the question, whether or not they intentionally provided false information and about the tax obligations, and whether Capital Finance reasonably relied on that information, and whether there's evidence to support the district court's conclusion that there was a wrongful diversion of those payments to Medicaid funds. So you may be offering a reasonable interpretation otherwise, but that doesn't negate the trial court's
finding if it is supported by clear and convincing evidence. It doesn't have to be absolute. It just has to meet that standard.
I agree, Your Honor, and where we certainly don't believe, and we believe the court erred in finding that there was clear and convincing evidence that the bank or that Capital Finance reliance was reasonable. We know that approximately 6 months prior to the loan of the $1 million at issue here, that the first default under the CSA was issued. Mr. Stein testified that he had nearly daily conversations with, Your Honor, may I continue?
Yes, sir. You go ahead. Answer. You finish your answer. You don't have to stop mid-comma with me.
Okay. Thank you, Your Honor. Mr. Stein, on behalf of the bank, testified that he had nearly daily conversations with Mr. Newman about the financial health and well-being of the borrower. He was aware that 2 of the 8 entities had to be scuttled. He was aware of the financial distress. Capital Finance had switched to paying only discretionary payments. And notwithstanding all of those facts, Capital Finance has argued, and we don't, certainly our position is that doesn't rise to clear and convincing evidence of that their reliance was justifiable, simply because our argument is you should ignore all of those facts and the fact that they engaged an auditor with their contractual rights and they were actively participating with that auditor, and that the auditor was reviewing the financial health of the borrower. And simply because the borrower filled out a boilerplate pre-printed form, that is justifiable reliance to issue an additional $1 million to the borrowing entities that they were fully aware of were in financial distress. Capital Finance has argued that this court should take, when finding intent, should take into consideration the sophistication of Mr. Newman, but then ignores the sophistication of their own banking entity and professional lending entity in its conduct, and to claim that it justifiably relied.
Can I ask a follow-up on that, Mr. Dougherty? So that's not an unreasonable argument, but of course, what Capital Finance was doing here with respect to this particular loan agreement was it was making advances against accounts receivables that had already been earned at the time of each advance. So the fact that that your clients were having some financial difficulties in the present environment, while not completely irrelevant, I think a reasonable fact finder could find that, notwithstanding that, having received this certificate that suggested that all of the payroll taxes had been paid and therefore there was no concern about the government priming Capital Finance's otherwise first in line lien, that made it reasonable, entirely reasonable for Capital Finance to provide the advance, particularly since it was doing so in reliance on the fact of accounts receivables that had already been earned. Why is that not a reasonable view that the district court could take?
Well, Your Honor, to ignore the knowledge that Capital Finance has precludes Capital Finance from getting to its clear and convincing burden of proof.
Well, so I don't know that the district court ignored that evidence. I think the district court may have accounted for that evidence and found that, notwithstanding these problems that were looming on the horizon and perhaps were present with respect to the overall financial health of these nursing home facilities, that the fact remained that there were accounts receivables that had been earned and booked, and that was the sort of the linchpin and the accompanying certificate that suggested that there were no problems with the payment of taxes, in particular payroll taxes, that made it reasonable to continue to advance funds, notwithstanding all the points that you have raised about the difficulties that the entities were facing at the time. That's more of a statement, I guess, than a question, but if you can respond if you'd like.
Thank you, Your Honor. Our position and our belief is that was not a reasonable conclusion given their own sophistication as the lending facility and all of the financial issues that they were both observing, and then the conduct they based upon those observations, including bringing an auditor into the fold they were actively participating and interacting with Capital Finance, being there, and that the auditor was issuing formal findings shortly after the money was sent. To simply take a pre-printed form is not reasonable reliance.
Very good, sir. Appreciate it. We've given you plenty of extra time, and you have some time reserved. Let's hear from Mr. Dorsey.
May it please the Court, this is William Dorsey for the Appellee Capital Finance, LLC. I think as has already been discussed pretty extensively in this case, we believe that Judge Bennett correctly interpreted the guarantee and appropriately ruled in favor of the plaintiff on not just the breach of guarantee claim, but also the fraud, conversion, and punitive damages issues. I'll turn first to the guarantee and the triggers. I would just add briefly that the bankers and shippers case found that it was the clear and unambiguous meaning of the contract that the "and" should be read disjunctively in order to, quote, effectuate the intent of the parties. And so we do believe that it's unambiguous that this should be read in the disjunctive, and that's exactly what the bankers and shippers case has held. It's exactly what was held in the fidelity and deposit case, and we believe it's the only proper interpretation here. To the point that was raised earlier by, I believe it was Judge King, there was a reference to the findings of the district court, and he specifically found that Mr. Stein, who is the banker at Capital Finance responsible for this loan, that he had explained that this type of provision, the trigger for the guarantee with the three, triggering events, was widely used and designed to incentivize the principals of the borrowers to act in accordance with the credit agreement, and that in his experience it would be highly unusual for the three conditions to occur at once. I think he was being perhaps understating it. And then it said, accordingly, Stein understood the provision to require the occurrence of only one of the three conditions precedent listed. And then it goes on to say that this court specifically finds that Mr. Stein was a credible and honest witness. So to the extent that there is any potential ambiguity in the contract, and we don't believe there is, certainly the court has made factual findings that would support the conclusion that that's what the parties intended through this provision. Turning now, unless the court has any questions on that issue, to the conversion claim, I wanted to just be clear here, because I think that the record is a little sparse in what was raised by counsel here about the circumstances. Capital Finance had a lien on all accounts of the borrower in this instance. And accounts means money paid and money owed to the borrower, including any bank accounts held by the borrower. And in this agreement, there was a requirement that all funds be deposited into what's known as a blocked account. The blocked account allowed Capital Finance to have a security interest over those funds through a deposit account control agreement, and allowed them to, in the event of a default, sweep those funds. It is, I believe, uncontested that monies collected from intergovernmental transfers and Medicare payments were deposited into a different account that was not held through the DACAs and was prohibited under the terms of the loan agreements. And so therefore, the suggestion that those funds were not converted is unsupportable. Once the funds got there, there was still an obligation for those funds to be returned, even if they were deposited by a third party. Demand was made for those returns, and this is what's sort of not been addressed to the court yet. There were demands, and this was raised at the trial court in the testimony and in the documents. There were demands made once Breslin and Young had started looking at these issues to return all of the converted funds, and Mr. Newman actually returned some of them, but not all of them, in response to those demands. Never once did he suggest that these were not the accounts of the borrower or the collateral of Capital Finance. So for them now to suggest that there's...
Can I ask?
Yes.
So there was a demand for return of the funds, but I mean, it literally was not a demand for the return of the specific cash bills or money that were deposited in the account. It was just a demand for reimbursement of money, not any particular pot of money. I'm having trouble understanding. I mean, ultimately, the right here was a right to payment, not any specific, suitcase or stash of funds. That's the issue I have with respect to this conversion claim. But frankly, I don't know if that matters in the context of this case, because even if you're wrong on that, I don't think it changes the result. But go ahead.
Yes. So conversion is available when there's a specifically identified group of funds, and Breslin and Young specifically identified the funds that had been diverted from intergovernmental transfers in Medicare. And I don't have the demand in front of me, but I believe that the demand specifically identified the funds that had been deposited into the wrong accounts and demanded that those funds be returned, so that those amounts could be applied to the loan balance. So when you're talking about...
Let me just ask you a practical question. So if they had, in fact, just simply gone to a different account, a personal account, and deposited those monies into the account, are you saying that they wouldn't have complied with the requirement to return the funds because they didn't return the precise cash bills or monies that had been taken out initially?
Well, would there have been, if new money had been put in to replace the money that was specifically identified? I agree, we probably wouldn't have been bringing a conversion action, but I think that it satisfies the elements of the claim that there was a demand made for the specified amounts because they were identifiable, and that's exactly what Mr. Young did in going through all of the account records and identifying the improperly deposited money. For instance, if a non-IGT or Medicare payment totally unrelated to the borrowers had mistakenly been deposited into the Chase account, that wouldn't be conversion. We wouldn't have a claim for those funds. This is money that are defined as accounts. They're identifiable, and they were put into the wrong account, and they refused to put them into the right one. In fact, hundreds of thousands of dollars disappeared from that account.
Isn't there some evidence in the record that some of these funds were commingled once they were deposited into the Chase account?
There was record that these funds were deposited with other money into the Chase account. We did not trace all the way to the end of the line whether there were additional funds that were converted and whether these were all accounts of the borrowers. And we did not make a claim for the funds other than for what was deposited from Medicare and IGT into those accounts. So we've limited the claim.
My point is, doesn't that sort of weaken the claim that there's a commingling of funds, that there really wasn't the kind of segregation that would be necessary to make out a claim of conversion?
I understand the law to be that it does not eliminate a claim for conversion for the funds to be deposited into another account as long as they're identifiable. And we have bank statements confirming which funds were deposited into the account and demanded the return of those funds.
Okay.
Turning briefly to the issue of reasonable reliance, again, I want to be careful about how these facts have been characterized. Our client was aware of financial difficulties of a borrower, and in response to that and subsequent meetings with the borrower, took action, including the hiring of an expert who was tasked with going through the accounts of the borrower to find out what was going on. And it was only after that report was issued and it confirmed the intergovernmental transfer and the Medicare diversion, as well as the failure to pay payroll taxes, that a subsequent default notice was issued and the actions that were taken here were done. I don't think it's a reasonable conclusion, much less one that's something that could result in the upsetting of this the trial court's determination, to suggest that a bank has an obligation or is on notice that a borrower is failing to pay payroll taxes or is stealing money just because it's in financial distress. The time period between when the report was issued by Breslin and Young and the default notice issue and action was taken is, I think, a matter of days, and that is a perfectly reasonable response. And it's clear that the bank reasonably relied on the statements, and that's exactly what the court found. So we believe that that finding, as well as the finding of intent, is fully justified. There wasn't much talk of the evidence of intent here, but the suggestion that the court erred by concluding that Mr. Newman acted with intent in submitting false borrowing-based certificates is unsupportable. Mr. Newman had years of industry experience. He was the one solely responsible for the operations of the business and solely responsible for the accounts that were controlled by the borrower, and knew he had to make representations about the borrower's financial health to Capital Finance in order to obtain advances under the loan. He also signed the same form borrowing-based certificate every time advances were requested, which was tens and tens of times in this instance. And so to suggest that he didn't bother to read what he was representing or didn't know that it was false when everybody now knows it was false is, it certainly is not clearly erroneous to reach that conclusion, and we don't think it's an appropriate inference to draw from the facts, even if it weren't under the standard. So, we would ask that the court affirm the finding of the trial court in total and deny the appeal. Happy to answer any questions that you may have, though, going forward.
Thank you very much, sir. Doherty?
Thank you, Your Honor. Regarding the court's questions about the conversion claim, we certainly agree that it is the exception that money can be converted, and that in this factual scenario, it would be improper to convert it. That the court's questions were exactly correct. That this was a demand for reimbursement, and quite frankly, if the Capital Finance's position is that once that they held the lien on the collateral, that once it was paid into any account of the borrower, then they already had that lien established, and it simply was a demand for reimbursement, in addition to the concerns about commingling of funds and it not being a specific suitcase full of specific bills. So we certainly agree that in and of itself, either of those issues would doom the conversion claim, and it should be reversed regarding that. To address counsel's point about bankers and the bankers and shippers case, which the court also relied on, that was an insurance contract. The parties specifically agreed and intended to provide insurance and seek insurance. This case is different in that the guarantee at issue here were specifically agreed and intended to be limited. There is a dispute, obviously, between the parties on how limited. So the unambiguous reading of the and throughout the contract is in the conjunctive and should continue to be in the conjunctive here, which isn't opposed to the bankers and shippers case. It actually comports with the bankers and shippers case, because in that case there would be no insurance, which was the specific intent of the parties to create an insurance contract. In addition, if two pilots were required to fly the plane, as the court found, it would likely result in catastrophic disaster. So that's why the bankers and shippers case does not preclude the result we are advocating for, because while it is possible for these three events to occur, albeit unlikely, But more specifically, the intent of the parties was for this to be a limited guarantee. And Mr. Stein and the evidence offered is years later. There's no evidence that this was ever discussed, that this clause was ever discussed, and how limited the limited guarantee should have been. We only have, as offered by Capital Finance at trial, and which their burden was that Mr. Stein now, years later, in a post hoc explanation, was that no, they intended it to be each individual position. And then regarding, counsel commented about how to infer intent based upon, again, Mr. Newman's sophistication. Certainly our position is Capital Finance is taking a sort of cake and eat it too type of argument of you should take into consideration Mr. Newman's sophistication, but ignore the bank's sophistication and ignore the bank's conduct to date and find justifiable reliance and support to support the claim of fraud. Therefore, it's our position that the torts should be both dismissed and judgment should be reversed on the entire case, but specifically certainly the torts, which would also then preclude a finding of punitive damages. And I believe I have about 20 seconds left if the court has any additional questions.
Hearing none, Mr. Daugherty, I want to thank you for your arguments. Well, those your opposing counsel will take this case under advisement. And Madam Clerk, I believe we can adjourn not just for the day, but sine die.
Yes, sir. This honorable court stands adjourned. Sine die. God save the United